We will discuss chapter 2 of BNSS in this video, and it contains criminal courts in India. And here section 6 to 13 provides court of sessions and the judicial magistrates. Their jurisdiction, their power to sentence, we will discuss in their hierarchy and subordination. So we are going to discuss all about court of session and judicial magistrates. Section 6 of BNSS provides classes of criminal courts, and it says besides high courts and the courts constituted under any law other than this Sanhita, there shall be in every state the following classes of criminal courts. So it says that besides high court, so high court is always considered as a criminal court, and besides the high court and the courts constituted under any law. So there are courts constituted under other laws, some special laws where the special courts are established. Other than those courts, this court provides these following categories of courts in India, in every state, it says. So first, court of session; second, judicial magistrate first class; third says the judicial magistrate of second class; and fourth is executive magistrate. So thing to remember is that executive magistrates are also considered as a criminal court, although they do not try the offenders. They just do the work, as I have discussed in the previous video, that what executive magistrates are empowered to do in this court. So not the trial and the performance of work which is exclusively for the judicial magistrates, that cannot be performed by executive magistrates, but it is a criminal court. So you should remember that High Court, Court of Session, JMFC, JMSC and executive magistrates are criminal courts. And also it says that besides the High Court and the courts constituted under any other law. So it says that besides both these categories, which means High Court and the courts constituted under any other law are also criminal courts, and besides High Court and those courts, these categories of courts are also criminal courts. So if you know about that Atrocities Act provides establishment of a special court, which is of which the presiding officer is always a court of sessions judge, presides the atrocities special court. So that court is also considered as a criminal court because it tries the offences under that special law. So that is also included in this provision. Now with section 6, it is important to cover section 21 of the BNSS, which provides courts by which offences are triable. So by what courts offences can be tried in this code is provided in the section 21, and it says subject to other provisions of this Sanhita. A. Any offence under Bharatiya Nyaya Sanhita, which means earlier IPC, may be tried by High Court or Court of Session, any other court by which such offences shown in the first schedule to be triable. So it says that the offences under BNSS can be tried by High Court or Court of Session or any other court by which such offences shown in the first schedule to be triable. So it is the other courts are JMFC or Judicial Magistrate second class. This is the remaining category. So there is a schedule 1 which provides what courts, what offences are cognizable, non-cognizable, bailable, non-bailable, and also who may try the offences. So there is specified in first schedule what court is to try what offences. But there is a proviso. It says that provided that any offence under 64, 65, 66, 67, 68, 69, 70, 71 of BNS shall be triable by, as far as practicable by presiding officer who is a woman. So it says what offences provided under BNS, these offences are against women, and they should be tried by a court presided over by a women judge. So this is a clause that as far as practicable, if the women judge is not available, obviously it shall be tried by a man judge, a male judge, and if women is available, as far as practicable, how much it is possible practicable, only then it is a mandate by the provision that it should be tried by a women judge. Those offences against the child or women provided in the Act. Then clause B says any offence under other law. So earlier we in clause A discussed offences under BNS, but it says under any other law, when any court is mentioned in this behalf, in such law be tried by such court, and when no court is mentioned, by triable by High Court or any other court by which such offences shown in the first schedule to be triable. So if first schedule provides for the trial of those offences under any other law, and that court or a High Court, or if the court is mentioned in that other law, that court shall try the offence. So this is clear. Now section 7 provides territorial divisions. So A says every state shall be sessions division or shall consist of sessions divisions, and every sessions division shall for the purpose of this Sanhita be a district or consist of districts. So it says that there shall be either in every state there shall be a session division or sessions divisions, one or many, and each shall be a district for the purpose of provisions of this Sanhita. Subsection 2 says the state government may, after consultation with the High Court, alter the limits of or the number of such divisions and districts. So alteration of limits of divisions or districts can be done by the state government, but after consultation of consultation with the High Court, because it is for the purposes of the provisions of this Sanhita, then that's why High Court is to be consulted before doing so. Subsection 3 says the state government may, after consultation with the High Court, divide any district into subdivisions and may alter the limits or the number of such subdivisions. So again, by the state government, with consultation with the High Court, divide the districts into subdivisions. Earlier it was in subsection 2 about the alteration of the limits or number of the divisions. Here the division of the district into subdivisions. So again the consultation is required with the High Court and can be done by the state government. Subsection 4 says the sections, divisions, districts and subdivisions existing in a state at the commencement of this Sanhita shall be deemed to have been formed under this section. So the existing divisions and subdivisions are to be deemed to be the divisions or districts which are formed. It shall be regarded as they are formed under the provisions of this act, under this section. So let's try to understand this through a table. So a state, there shall be a state. So there are states already, and in state there either will be session division or sessions divisions, right? And then those shall be regarded as district. If single is a district and there are many divisions, then all divisions shall be districts. And for further, the state government, in consultation with the High Court, alter the limits of divisions or divide districts into subdivisions. So this is what mostly the provisions is all about. Then comes section 8, court of session. Earlier in CRPC it was section 9. Here section 8, the state government shall establish a court of session for every sessions division. So each session division shall have a court of session, and then every court of session shall be presided over by a judge appointed by High Court. So each session session division shall have a court of session judge to be appointed by the High Court. Establishment of court of session is under the hand of the state government, but the appointment of presiding officer as a sessions judge is to be done, appointment to be done by the High Court. So the difference is very clear. Establishment of the court is the duty of the state government, but the appointment of the presiding officer is the duty of the High Court. Then subsection 3, High Court may also appoint additional session judges to exercise jurisdiction in a court of session. So there can be additional session judges also, again to be appointed by the High Court. Subsection 4 says the sessions judge of one session division may be appointed by the High Court to be an additional sessions judge of another division. So this can be done that a judge is a sessions judge of one division, for example of some district in any state. It can be an additional judge in another division of that state, and that means that another division may be under a district, or there may be so many divisions in a state, so it can be another district there and he can be an additional judge there. And in such case he may sit for the disposal of cases at such places or places in other division as the High Court may direct. So this is to be directed by the High Court only, that where he is to dispose of the cases, where he has to sit, and also the appointment here of whether he can be of additional session judge of another division is to be done by the High Court. Now subsection 5, it says that where the office of sections judge is vacant, when the office of the judge is vacant, which means not the absence of a judge. Vacant means the judge is not there, is no presiding officer posted there. So if it is vacant, the High Court, it is the High Court, not the principal judge, it is the High Court, may make the arrangements for the disposal of any urgent application which is or may be made or pending before such court of session by an additional sessions judge, or if there be no additional sessions judge, by a Chief Judicial Magistrate. So first, the urgent applications. It is only about urgent applications. If the post is the sessions judge chair is vacant, then the High Court make arrangements only for the urgent applications, and they can be either be decided by the additional session judge, and if there is no additional session judge, by a Chief Judicial Magistrate in sessions division. And every such judge or magistrate shall have the jurisdiction to deal with such application. So this is subsection 5. Then comes subsection 6, the court of session shall ordinarily hold its sitting at such place or places as the High Court may by notification specify. So its sittings to be controlled where the judge shall sit and try the offences, do its proceedings, it is to be done by the High Court only. It will specify through a notification. But if in any particular case the Court of Session is of opinion that it will tend to the general convenience of the parties and witnesses to hold its sittings at any other place in the Sessions Division, it may, with the consent of the prosecution and the accused, sit at that place for the disposal of the case or the examination of any witness or witnesses. So, for the disposal of the case and examination of the witnesses, and it should be in the convenience of the parties, and that should also be with the consent of the prosecution and the accused. So, it should also be within the same session division within the state. It should be the same session division, and the place may be different, but under the same session division, and the consent should be there of the prosecution and the accused. Now comes subsection 7. It says the sessions judge may from time to time make orders consistent with this Sanhita as to the distribution of business amongst additional sessions judges. So, it is kind of a roster, as it happens in High Court and Supreme Court, that there is a roster system where the chief decides what cases are to be distributed amongst what judges. So, there are number of judges here in where we talk about the sessions division, which is a district. There the principal judge decides who shall be the what cases are to be distributed amongst additional sessions judges. And about the magistrates, it is the chief judicial magistrates who distributes the cases amongst the magistrates. So, for sessions for additional sessions judges, it is the sessions judge who the principal session judge who distributes the cases. And how it happens in High Court, the Chief Justice of the High Court and Chief Justice of the Supreme Court makes a roster for cases to be distributed. So, it is the discretion of the session judge here. Now, subsection 8 provides the session judge may also make provision for the disposal of any urgent application in the event of his absence or inability to act. So, earlier in subsection 6 we talked about when the judge is the post is vacant, there is no judge presiding officer, and then there the arrangement is to be made by the High Court. Here it is a little different, because when the judge is absent, so when the session judge is absent, not the post is not vacant, he is absent, and either he is unable to act. So, in his inability to act and in event of his absence, he can make an provision for the disposal of any urgent application. So, this is common that it should be for the urgent hearing, urgent applications. For that he may make a provision by an additional session judge, or if there is no additional session judge, by a CJM. So, those applications to be either heard by the additional session judge, or if there is no additional session judge, by the CJM, and such judge shall have deemed to have jurisdiction to deal with such applications. This is subsection 8. Now, there is an explanation provided, and it says, for the purposes of this Sanhita, not this section, for the purposes of this Sanhita it says, and it says appointment does not include the first appointment, posting or promotion of a person by the government to any service or post in connection with the affairs of the union or a state, where under any law such appointment, posting or promotion is required to be made by the government. So, here the appointment does not include the first appointment, posting or promotion. The simple reason is that first appointment, like if you take example that a civil judge is appointed by the state government into the service, and his first appointment and its posting is generally done by the government, the state government, and afterwards that appointment, the further posting and transfer and their promotion done by the High Court. So, whenever it is the first appointment, it is done by the state government. So, here you see the provisions, in the provisions the appointment is to be done by the High Court, whether it is the Court of Session, it is the Judicial Magistrate, additional sessions judges, all these appointments are to be of the presiding officer is to be done by the High Court. So, that is why here in this explanation the code has clarified that under this Sanhita the appointment does not include first appointment, because that is to be done by the state government. Here the appointment is to be done by the High Court. So, that is why it is not the first appointment. It is the subsequent conferment of the power, you can say, by the High Court to these posts provided in this whole code. Now, coming to the section 9, courts of judicial magistrate. So, subsection 1 says, in every district there shall be established as many courts of judicial magistrate of first class and second class, and at such places as the state government may, after consultation with High Court, by notification specify. So, there shall be two classes of magistrates, judicial magistrate first class and second class. And judicial magistrate magistrate first class, second class, there shall be a number of posts, the courts of JMFC and JMSC in every district, and at such places as the state government may, after consultation with the court, high court specify. So the state government shall specify with the consultation of the high court. Then proviso says, provided that the state government may, after consultation with the high court, establish for any local area or one or more special courts of JMFC or JMSC to try a particular case or particular class of cases, and where any such special court is established, no other court of magistrate in the local area shall have jurisdiction to try cases or class of cases for trial of which such a special court of judicial magistrate has been established. So it says whenever there shall be a provision for special court if the state government specify with the consultation of the high court for any local area for particular cases, to try particular cases, special court of JMFC and JMSC can be there, and no other court shall have jurisdiction when what cases these courts are established to try. Only those special courts will have jurisdiction to try such particular cases. Now establishing a special courts is not mandatory. It is on the discretion of the state government to establish such courts. It is not a mandatory provision. Now subsection 2 says, presiding officer of such court shall be appointed by high court. So presiding officer of such court means the JMFC, JMSC and the special court as well. So presiding officer shall always be appointed by the high court. Then subsection 3 says the high court may, whenever it appears to it be expedient or necessary, confer the powers of a judicial magistrate of first class, second class on any member of judicial service of the state functioning as a civil judge, a judge in a civil court. So if you see in the most of the high courts in most of the states, whenever a judiciary aspirant is selected and he is given a posting, he is generally given posting as a civil judge, not as a judicial magistrate. A civil judge, when he is selected and he is posted, he is always, as a practice, as a rule there, a general practice in most of these states, is given power as a judicial magistrate, and they work as initially as a second class, and then further after 6 months or a year they are given power of a judicial magistrate of first class. This is the provision through which this exercise is done, subsection 3. Now section 10 says chief judicial magistrate and additional chief judicial magistrate. Now to remind you again that the court of metropolitan magistrate and chief metropolitan magistrate as well as assistant sessions judge post has been eradicated. There is no such post in BNSS. It was there in IPC, but now this is a change. There is no metropolitan magistrate here in BNSS. So section 10 says CJM and additional CJM. Subsection 1 says in every district. So this is about district. The high court shall appoint a judicial magistrate of first class to be CJM. Only JMFC can be a CJM, not the JMSC. In every district, should be in a district. Appointment by high court only. Then subsection 2 says the high court may appoint any judicial magistrate of first class to be an additional CJM. So subsection 1 is CJM, second additional CJM, and such magistrate shall have all or any of the powers of CJM under this Sanhita or any other law for the time being in force as high court may direct. So additional CJM shall have power of CJM. Then subsection 3 says the high court may designate any judicial magistrate of first class in any subdivision as the subdivisional judicial magistrate and relieve him of the responsibilities specified in this section as occasion requires. So this was not the provision, this is a new provision that a JMFC can be a subdivisional judicial magistrate. This was there was no such provision earlier. This is a new provision. It is like the post there of subdivisional magistrate, SDM, as a who is a executive magistrate, but whenever the revenue powers are to be exercised, it is called SDO. So this is a post like that, and it is a new provision. Now subsection 4 says subject to general control of CJM, every subdivisional judicial magistrate shall also have an exercise such powers of supervision and control over the work of judicial magistrates other than additional chief judicial magistrate, and in the subdivision as the high court may by general or special order specify in this behalf. So in subdivision, a subdivisional judicial magistrate shall have power of supervision over the work of the judicial magistrate except the additional chief judicial magistrates, and it is subject to the general control of the CJM. So it is the provision that subdivisional judicial magistrate having power of supervision over the other judicial magistrate in same subdivision, and it is as directed by the high court as it is provided, and It is not for the additional Chief Judicial Magistrate, and it is subject to general control of the CJM. So this is subsection 4. Now section 11 provides special judicial magistrates. So the High Court may, if requested by the central or state government, so it is only when the request is there by the central government or from the state government, and the High Court may, on such a request, confer upon a person, it is the conferment, who holds or has held any post under the government, all or any of the powers conferred or conferable by or under this Sanhita on a judicial magistrate of first class or of second class in respect to particular cases or to particular classes of cases in any local area. So this, so the High Court can confer the powers of JMFC or JMSC on any person who holds a post under the government, all the powers of JMFC or JMSC, and this is that court shall be the magistrate. It will be called as a special judicial magistrate to try the particular cases and classes of cases in any local area. So this is to be done by the High Court only upon the request of central or state government. Now, provided that no such power shall be conferred on a person unless he possesses such qualification or experience in relation to legal affairs as the High Court may by rules specify. So the essential qualification must be met before such appointment, and subsection 2 says such magistrate shall be called a special judicial magistrate and appointed for a term not exceeding 1 year at a time, as the High Court may by general special order specify direct. So this is the appointment is just valid for 1 year, and it can be renewed after that. Now section 12 is there, and it says local jurisdiction of judicial magistrate. So subsection 1 says subject to control of High Court, the CJM may from time to time define the local limits of area within which the magistrates appointed under section 9 or 11 may exercise all or any of the powers with which they may respectively be invested under this Sanhita. So the jurisdiction of a judicial magistrate is subject to control of the High Court, is to be regulated by the CJM under what limits and what areas these judicial magistrate shall exercise the powers of such courts. So this is to be done by CJM, but subject to the control of the High Court. Then provided the court of special judicial magistrate may hold its sitting at any place within the local area for which it is established. So obviously if it is about the special judicial magistrates, they are appointed and such courts are established only for some local area, so they will continue to have power for such local area for which they are established. Now subsection 2 says except as otherwise provided by such definition, the jurisdiction and powers of every such magistrate shall extend throughout the district. So the jurisdiction in general of the magistrate shall extend throughout the district. Where the local jurisdiction of a magistrate appointed under section 9 or 11 extends to an area beyond the district in which he ordinarily holds court, any reference in this Sanhita to the court of session or chief judicial magistrate shall in relation to such magistrate throughout the area within his local jurisdiction be construed unless the context otherwise requires as a reference to the court of session or chief judicial magistrate, as the case may be, exercising jurisdiction in relation to said district. So it simply says that whenever the CJM, whenever the JMFC or JMSC appointed under section 9 or 11, the special magistrate appointed, and they are having jurisdiction, their local jurisdiction extends to an area beyond the district in which he ordinarily holds court, then the reference to CJM or court of session shall be construed accordingly. So if that area comes within another district, then the court of session or CJM of that another district shall be the court of session or CJM. They shall have the power of supervision. So this is subsection 3. Now section 13 says subordination of judicial magistrates. So subsection 1 says every CJM shall be subordinate to court of session, and every other judicial magistrate shall subject to general control of session judge be subordinate to CJM. So general control of session judge shall always be there, and all the magistrates are subordinate to CJM, but CJM is subordinate to court of session. So this is subordination. Subsection 2 says the CJM may from time to time make rules or give special orders consistent with this Sanhita as the distribution of business among the judicial magistrates subordinate to him. So you see the work, the business of magistrates is to be distributed amongst them by the CJM. There is an important case, Mansoor versus State of MP of 1986. It was held that the executive magistrate are subordinate to court of session, but the court of session cannot transfer cases from executive magistrate to another, and that can be done only by the district magistrate. So their business, their distribution, and their the administrative
functioning is always controlled by the district magistrate, but whenever it comes to the judicial powers, the executive magistrates are always subordinate to court of session. So this was held in this case. Here I have produced the hierarchy of the criminal courts and their power to sentence. So this on top it is the Supreme Court, and then comes High Court, and then Sessions Judge, additional Session Judge, CJM, and then also additional CJM and sub-divisional judicial magistrate can also be there now in this hierarchy. Then comes JMFC and then JMSC. This is the hierarchy, and there is obviously the special courts are there, and they can also be here accordingly. If it is a special court presided over by the Sessions Judge, then it will come here, and of magistrates will come here. The Supreme Court and High Court can award sentence, any sentence authorized by law. It is given under section 22. And then Sessions Judge, additional Session Judge can also pass a sentence, any sentence authorized by law, but the sentence of death is subject to confirmation by High Court, which we will discuss later in the later provisions of the Act. And it is for the additional Session Judge and Session Judge both. Earlier in CRPC there was assistant Session Judge also who could pass only sentence up to 10 years. Then now it is abolished. CJM is there, and it can pass sentence except death, LI, or of sentence exceeding 7 years. So up to 7 years sentence is the power of CJM. For JMFC, it is given under section 23. A power of sentencing power of all three, CJM, JMFC, JMSC, is given under section 23. JMFC can pass sentence not exceeding 3 years, or a fine not exceeding 50,000 rupees, or both. And also the new punishment provided introduced is community service, can also be one of the sentences which the magistrate can pass. And second class can pass a sentence not exceeding 1 year, a fine not exceeding 10,000 rupees, or of both, or of community service. So this is the hierarchy and the power to sentence provided in the code of for the criminal courts. Now I hope you liked the video and it was helpful for you, and for more such videos please subscribe the channel. Thank you for watching.